Well, great to be amongst you here today. Thanks, Mike, for the invitation to speak. Thanks, Dominic. I think you're there somewhere for hosting for us today. So it's lovely to be back in Annandale. I spent student years in this area, and I think I walked past what was a tenancy that myself and a mate looked at in Annandale, and we turned it down because it was underneath a dog grooming shop. And so the smell had just infected this place. And we found a place instead in Petersham where the problem there wasn't dogs, it was rats and mice. But anyway, such is life in inner city Sydney as a student. So today I've chosen the topic of a contested jurisprudence, navigating the maze that is religious freedom in 21st century Australia. This capacious and possibly non-committal title was really just to allow Mike to keep moving ahead and affording me time to work out what I wanted to say. Since adopting that title, I have found the wherewithal to commit to something more concrete, and I've decided to address the following three areas that I cannot see otherwise to be canvassed from the podium today. I've chosen these three topics as they are currently confirmed proposals for Commonwealth legislative reform. They are also key areas which will determine whether religious freedom is preserved in this country for years to come, at least so far as the preservation of religious freedom arises as a matter of judicial consideration. Of course, religious freedom doesn't just concern judges. There's a lot of freedom that is innate to us as believers that we don't confer upon courts, but in these respects we are conferring things upon courts. The three contemporary areas of reform are, first, the Australian Human Rights Commission's proposal for a Federal Human Rights Act. Second, the Federal Labor Government's proposal for a religious vilification prohibition. And third, the Federal Labor Government's proposal for a prohibition on religious discrimination. Let's start with the first. The Australian Human Rights Commission's mooted Australian Human Rights Act proposes to enact a regime of rights that draws upon but substantially modifies Australia's obligations under existing international covenants. The Australian Human Rights Act also draws upon but modifies existing state charters enacted in the Australian Capital Territory, Victoria and Queensland. It contains several core propositions. A breach of the Act's rights will be justiciable through a specific positive duty imposed on public authorities to act compatibly with human rights and give proper consideration to human rights when making decisions. Public authorities limiting human rights must establish that their actions are proportionate. Parliament would be required to consider human rights when making and debating laws. The courts will be required to interpret, quote, all primary and subordinate Commonwealth legislation, so far as is reasonably possible, in a manner that is consistent with human rights, as stated in the Human Rights Act itself and also international law. The Attorney-General must commence a review of the law wherever a court finds that legislation is incompatible and bring this finding to the attention of the Parliament. The Commission posits that this framework will ensure that, quote, human rights are embedded within the laws of our country. The following comments draw upon my opening remarks to the Parliamentary Joint Committee on Human Rights inquiry into this proposal, given a little over 2 weeks ago. My view is that the Parliament should not enact a Charter of Rights. I have four main concerns with the particular proposal offered by the Human Rights Commission. Each of these concerns proceed from an understanding of the ways in which human rights are to be distinguished from legal rights. From the pre-Socratic philosophers Heraclitus and Parmenides, to Aristotle, to Aquinas and to Rawls, justice has always been understood as an exercise in spanning the divide between the general and the particular, where, quote, the general universal statement is inadequate insofar as it is indeterminate with respect to particular situations, while the more specific universal statement, though more determinate, is nevertheless liable to mislead. And I thank Dr. Deegan for that quote, which I lifted from his PhD, which I commend to all of you to read. Human rights charters sit at the general end of this ancient spectrum, Justice applied to individual circumstances in a courtroom sits at the specific end of that spectrum. My concerns with the proposed Human Rights Act are as follows. First, human rights claims are often made as a fait accompli, intended to conclude a debate, but closely observed are often simply another political claim amongst many. As Professor John Griffith has said, abstract rights formulations are the, quote, statement of a political conflict pretending to be a resolution of it. It follows that the claim that human rights charters enable consensus must be questioned. Second, the proposal undermines confidence in the judiciary. It requires judges to interpret Australian law against principles that are purposely abstract and imprecise, requiring judges to determine the substantive content of the law in question and therefore make law. Being abstract, human rights do not in themselves state what justice requires in any given situation. Within the context of the Australian Human Rights Commission's proposal, this concern arises in two main ways. First, through the requirement that all Commonwealth legislation be interpreted according to the imprecise, abstract human rights stated in the Charter. The second is through the proportionality test within the proposed General Limitations Clause. The potential of this test to turn judges into lawmakers is plainly seen in the direction the proportionality test has taken under the UK's Human Rights Act, which also purports to enshrine a dialogue model. Professors Aroney and Eakins have written that statutory bills of rights encourage activist elements in the legal profession to press for judicial intervention in support of politically contested moral and political positions. End quote. Because human rights are politically contested, canvassing matters such as the entitlements of suspected terrorists, restrictions in a pandemic, the limits of surveillance, or the expression of religious views in public life, judges can then be seen to be taking sides in a political debate, undermining confidence in the impartiality of the judiciary and its independence from executive government. Such matters should be resolved through vigorous, democratically accountable parliamentary debate, not unelected and unaccountable judges. This brings me to my third concern. Because the proposal draws the judiciary into lawmaking, the Charter undermines the proper function of the Parliament. The difficult questions that arise in the context of human rights concerns should be the subject of the great contest of ideas that ensues in the public forum of the Parliament, where their wide-ranging implications for all members of our diverse society can be properly considered and weighed. In the Australian context, the Senate adds a further layer of accountability through its important role of scrutinising legislation. Instead, a charter leaves the difficult matters that arise in the context of human rights claims to the courtroom, a setting only suitable for the consideration of the particular circumstances of an individual claimant and respondent. In litigation, a court's attention is directed to the precise, fact-specific matter before it. Unlike a parliament, a court is neither equipped nor able to take into account the full range of human rights implications of the particular claim for all groups within wider society. Further, as Professor Janet Hebert has argued, charters can affect the process of democratic deliberation and debate. She argues that human rights laws induce parliamentarians to govern like judges by producing legalistic legislation which distorts policy and political judgments regarding human rights concerns. My fourth and final concern on the Charter is that notwithstanding claims that the proposal respects the sovereignty of the Parliament and the independence of the judiciary, in light of the foregoing concerns, the proposal impacts on the classical relationship between the three arms of government. It can thus be conceived as being quasi-constitutional in nature. Given this expansive reach, if a Human Rights Act is to be progressed, it should be only legislated with bipartisan support. So they were my comments to the Parliamentary Committee. It should be noted that all of the foregoing contentions are completely coherent with a sincere respect for human rights. Indeed, by introducing significant ongoing uncertainty through the positing of abstract rights and tests such as the proportionality limitations requirement within a human rights charter can ironically have the effect of undermining human rights. Australia enjoys a comparably high level of freedom of association, largely due to prevailing cultural beliefs and social practices in this country, supported by the common law's traditional respect for freedom of association and a democratic system of open political contestation. If a specific concern arises that the human rights of citizens are not protected, targeted legislation can be crafted to address that concern, while avoiding all of the foregoing concerns. Now, that was where I finished my statement, actually, sorry. All of the foregoing concerns that might be agreed to by persons with no particular distinct concern for religious freedom. I suggest, however, that all religious believers animated by a commitment to sound, accountable and limited government in our country should be seriously concerned with the proposal for a Human Rights Act for those reasons. I now turn to consider the distinct impact of the proposal of an Australian Human Rights Act on the manifestation of religious freedom in this country. The following comments summarise the further concerns I outlined to the committee during questioning. First, the Commission's proposed Act allows that religious freedom may be limited where necessary, reasonable and proportionate. It provides that all human rights, including religious freedom, may be, quote, subject under law only to reasonable limits that can be demonstrably justified in a free and democratic society based on human dignity, equality and freedom. At two levels, this standard for limitation does not equate to the stricter applicable protections ratified by Australia in the International Covenant on Civil and Political Rights, 1966. First, Article 18.3 of that covenant provides that limitations on religious manifestation may only be permitted to the extent that they are necessary. That a requirement of necessity imposes a more stringent standard than that of reasonableness has been affirmed by the European Court of Human Rights in Handyside in the UK, where the court held that necessary does not have the, quote, flexibility of reasonableness. That principle has also been affirmed in Australian law in the off-sided view of Bowen and Gummow, interpreting the Sex Discrimination Act in Styles, where their honours said, the test of reasonableness is less demanding than one of necessity. This particular concern is, however, not limited to just the freedom of religion or belief. To illustrate how concerning the issue is for the purportedly protected individual, consider the list of other rights protected by the ICCPR's necessity standard, but subject to reasonable limitations in the Commission's proposal. The right to liberty of movement, the right to privacy during court proceedings, the right to hold opinions without interference, the right to peaceful assembly, and the right to freedom of association. Returning to religion, the second major area of concern is that the Human Rights Commission's proposal permits of limitations not only on religious manifestation, it also permits the state to impose limitations on the right to hold a belief. This is clearly inconsistent with international law. No limitations on the right to hold a belief are permitted. It is not clear how this twofold watering down of religious freedom will interact with, for example, the existing exemptions for religious institutions and schools in anti-discrimination law. As those exemptions preserve religious manifestation in corporate capacities, will the exercise of those exemptions now be subject to the general requirement that their exercise be demonstrably justified in a free and democratic society based on human dignity, equality and freedom, and also the proportionality test? We simply don't know. So that would be a vehicle for the undermining of religious freedom through community expression in the form of exemptions. These concerns are only accentuated when one considers the reach of the proposed Act, also modelled on the Victorian, Queensland and the ACT, including the requirement of public sector compliance, the required parliamentary assessment of legislation, and the requirement that the courts must interpret interpret all primary and subordinate Commonwealth legislation so far as is reasonably possible in a manner that is consistent with human rights, as stated in the Act itself. This proposal thus permits the Executive, the Parliament and the Judiciary to infringe the requirements of international law, while in the same movement giving an unsuspecting populace the perception that they are acting in conformity with human rights. Having ratified the ICCPR, the Commonwealth has the obligation to ensure its compliance. Persons asserting a breach of Australia's obligations under the ICCPR may take the matter to the UN Human Rights Committee. As noted by Eleanor Roosevelt's famous speech in support of the draft UN Declaration on Human Rights in 1948, the field of human rights is not one in which compromise on fundamental principles are possible. There is, however, a demonstrable reformist shift disclosed in contemporary Australian human rights legislation when measured against the international standards settled in the post-war period. When contrasted with those standards, the proposal and the state-based instruments on which it is modelled leave us with the distinct impression that what we are being sold as a bundle of timeless truths are actually subjective sentiments afloat anchorless in a sea of majoritarian normative wind. This does little to inspire public confidence in the purported raison d'etre of such legislation, its ability to protect minorities against democratic majorities. Rather, such acts appear to prove the long-held fear expressed by Thrasymachus against Socrates that justice is nothing else than the interest of the stronger. Okay, that brings me to the second of my three concerns. The Federal Labor Party's proposal for a Commonwealth religious vilification prohibition, first proposed as an amendment to the Religious Discrimination Bill in February 2022. The provision, if legislated, would regulate teaching in churches, synagogues, mosques, viharas, gurdwaras and other places of worship. Most concerningly, it would require all religious teaching in this country to demonstrate to a judge that it is both reasonable and in good faith. The provision tabled by the Labor Party in the House of Representatives when in opposition in February 2022 states that, quote, "It is unlawful for a person to engage in conduct on the ground of the religious belief or activity of another person or group of persons that is not in private and that a reasonable person would consider would threaten, intimidate, harass or vilify the other person or group on the basis of their religious belief or activity." The exception to the provision provides a person does not contravene this prohibition if the person establishes that the person engaged in the conduct reasonably and in good faith in the course of any statement, publication, discussion or debate made or held or any other conduct engaged in for any genuine religious purpose. There's a number of other genuine purposes, I'm just focusing on the religious purpose. And it then clarifies that a religious purpose includes, but is not limited to, conveying or teaching a religion or proselytising, modelled on the Victorian provision. Unlike religious vilification law in New South Wales, here, recently legislated, Queensland and the recent adopted prohibition in the Northern Territory, the proposed provision applies not only to individuals but also to religious institutions, so including schools. The provision protects both persons with a religious belief and persons not holding a religious belief. It would therefore protect an atheist or an agnostic hearer who a reasonable person would consider would be threatened, intimidated, harassed or vilified by a statement. For example, it would protect a religious person whose religious beliefs posit that intimate sexual relations should only occur within monogamous heterosexual relations, who is threatened or intimidated by a person who challenges those beliefs. Similarly, it would protect a religious person whose religious beliefs affirm diverse sexualities and who is threatened or intimidated by a person who challenges those beliefs. Consider a speaker who conveys the traditional religious precepts of one of the Abrahamic faiths on a matter of personal morality, accompanied by teaching on their God's judgment for immoral conduct. Would a reasonable person consider that such teaching is threatening or intimidating to a religious person who did not share the professed religious conviction on those matters of morality? Recent furores over similar public statements by religious believers or institutions have demonstrated that many people within contemporary Australian society are challenged, even intimidated or threatened, by statements about the eternal consequences of what is said to be immoral conduct. Should the Albanese government's religious vilification clause take the same form as proposed in 2022 by the then opposition party, and should the Albanese government religious discrimination bill adopt the same exemption for religious bodies as was approved by the Labor Party in opposition in February 2022, the resulting religious vilification prohibition would subject all religious teaching within places of worship across this country to state regulation. Concerns for the impact of the provisions on freedom of religion, association and speech arise under two separate aspects of the proposed provisions. First, the use of a reasonable person test within the prohibition, and second, the use of the reasonably and in good faith test in the exception to the prohibition. In respect of the first of these two tests, the proposed religious vilification prohibition is to be determined according to whether a reasonable person would consider the impugned comments are intimidating, threatening, harassing or vilifying to the other person or group. Writing ex curia in 2016, Justice Sackville proposed amendments to Section 18C of the Commonwealth Racial Discrimination Act to replace the existing test there with a generic reasonable person test, which is the same test now proposed by Labor in February 2022 for its religious vilification prohibition. So Justice Sackville stated that such a test would have the following effect. An objective test would involve reference to the standards of a reasonable member of the community at large. In practice, as in so many areas of the law, this would involve courts exercising judgment in the light of their assessment of prevailing community standards, taking account of the evidence adduced in the individual case. In a secularising society where religious views are increasingly in the minority, Justice Sackville's regard for prevailing community standards should provide significant cause for concern for religious believers. If Justice Sackville's understanding accurately conveys the meaning of the reasonable person test within Federal Labor's proposal, the section would require a court to weigh whether religious statements are threatening or intimidating according to prevailing community standards. As noted, it is commonly asserted that the traditional religious precepts of the Abrahamic faiths on a matter of personal morality are out of step with modern standards. Indeed, this assertion was made in January 2023 by the Australian Law Reform Commission in its consultation paper, Mooting Reforms to the Law Concerning Religious Schools, which will no doubt come up during the course of this day. In that paper, the Law Reform Commission stated that generally accepted moral standards within the Australian community now require that religious schools be prevented from imposing limitations on a person who has a protected attribute under the Sex Discrimination Act. In effect, the Law Reform Commission's proposition was that religious schools that impose such limitations are acting immorally. The comments of Justice Hayne and Monison the Queen in respect of the implied freedom of political communication summarise well the concern with the deployment of the reasonable person test in Labor's proposed vilification provision. He said, the very purpose of the freedom is to permit the expression of unpopular or minority points of view. Adoption of some quantitative test inevitably leads to reference to the mainstream of political discourse. This in turn rapidly merges into and becomes indistinguishable from the identification of what is an orthodox view held by right-thinking members of society. And if the quantity or even permitted nature of political discourse is identified by reference to what most right-thinking members of society would consider appropriate, the voice of the minority will soon be stilled. This is not and cannot be right. End quote. The foregoing comments concern the elements of the prohibition. The second concern I hold is in respect of the exception to the prohibition. In order for an act done for a religious purpose to access the exception, it must be done reasonably and in good faith. To date, the courts have varied significantly in their understanding of what actions are performed reasonably and in good faith in vilification litigation. Indeed, Gleeson and French have both recognised that the application of the reasonableness test and good faith test can be subject to disagreement by reasonable minds. In Brofo and the Human Rights and Equal Opportunity Commission, French recognised the vagaries of the good faith test when he said, with reference to the vilification prohibition of the Race Discrimination Act, the judgment which the court is called upon to make in deciding whether an act falls within Section 18D has the character of judicial opinion and assessment in the application of legal standards of ill-defined content. In difficult or borderline cases, judicial opinions may differ. Similarly, in declining the appeal from the Federal Court in Brofo, Gleeson said, the issue of whether the conduct in question in this case was reasonable and in good faith involved a matter of judgment on which minds might differ. Given the prohibition covers both religious institutions and schools, the good faith and reasonable tests confer upon judges an extraordinary granular discretion over the affairs of religious institutions. Moreover, this power operates over matters of religious practice, where personal judicial convictions as to what is in good faith or reasonable may well admit of significant variation. The third and final area I have chosen in this journey navigating the maze that is religious freedom in 21st century Australia is the Albanese government's promise of a federal protection against religious discrimination. It should not be forgotten that the Religious Discrimination Bill of 2022 passed the House of Representatives with bipartisan support before being pulled from consideration in the Senate due to the separate issue of discrimination against students in religious schools. That bill, originally proposed by the 2018 Expert Panel on Religious Freedom, was the subject of extensive consultation with stakeholders, including Australia's key religious leaders, many of whom will be in this room. Examples provided with the bill, offered by the Morrison government in February last year, accentuate the lacuna left in existing Commonwealth law and the lacuna in protections for residents of New South Wales and South Australia, where there is no prohibition on religious discrimination. A Catholic who is aggressively asked to leave a restaurant and banned after saying grace. These are examples in the explanatory memorandum of the bill. A Hindu told there is no place for someone who believes in things so different in the football team. An Islamic childcare operator declined Commonwealth funding because the approving official dislikes Muslim people. The striking deficiency that permits such practices must be remedied. The prior government's religious discrimination bill contained a raft of provisions that resulted from the extensive consultation process undertaken with religious leaders. These were supported by the Federal Labor Party. Those provisions included an override of state laws that prevent a religious school from, quote, giving preference in good faith to persons who hold or engage in a particular religious belief or activity in employment. In what would have been a first for Australian law, the bill also declared the long-settled principle of international human rights law that the legitimate exercise of religious freedom is not discrimination. Existing law that characterises religious freedom as an exemption from a more fundamental standard of equality does not reflect this principle. The language of exemptions contains some beguiling and at times untested philosophical presumptions. We do not say, for example, that the right of the press to free speech is an example from majoritarian imposed control. Similarly, we do not say the citizens' freedom to associate around common interest is an exemption granted by the state from compelled forms of association. Such laden terminology characterises religious freedom as a secondary right. The former bill addressed that long-running concern. A further major provision resulting from the consultation, and one that was welcomed by those keen to keep the state out of the church, was the introduction of provisions requiring judges to have regard to the genuine views of religious believers, either as complainant or respondent. This implemented the settled position developed by the highest courts in Australia, England, Canada and the US as a means to prevent judicial determination of doctrinal disputes. Concerns that charities could lose their tax status for advocating for a traditional view of marriage based on the requirement that they extend the public benefit, as has occurred overseas, were also addressed by the legislative package. Each of these reforms were regarded as significant and welcome moves for those concerned for the preservation of religious freedom in this country. They are worthy of the bipartisan support religious leaders called for on this issue last year, and which Mark Dreyfus declared that Labor seeks to encourage in his support to Parliament, in his speech to Parliament. In all of these respects, the former bill proceeded on the premise that, as then Prime Minister Scott Morrison stated, we continue to be a tolerant and mature society, one that understands the importance of faith and belief to a free society. Many will consider the coming Labor government reforms to religious discrimination law, to religious vilification law, and for the proposal of an Australian Human Rights Act to be the measure of whether or not the former Prime Minister was indeed right. Thanks very much. Thanks, Mike. So I've got a bit of time for questions.
There we go. It's about pressing the button.
It does help.
Excellent. Thank you, Mark.
Pleasure.
There's a lot to cover.
Yeah.
And
there's a lot going on.
I think the theme from yours and Monica talks is just how much we have to cover on these issues. Okay. Starting from, I think, a slightly more particular question, moving up, we have got, could a conservative Christian use proposed religious vilification laws to argue that they have been intimidated by LGBT, etc. activists?
Yes, yes. As I said in my comments, they could. Yep. They would have to satisfy the court that a reasonable person would consider that they were threatened or intimidated by those comments.
Yep.
Yeah, so it's not the individual subjective person before the court, it's the reasonable person. And as I said, Justice Sackville equated that to prevailing community standards, which is my concern. And I did say that the law in New South Wales, Queensland and the Northern Territory does not subject religious institutions to that prohibition. They have an exemption just by by sheer dint of the standing exemption in those acts.
Okay, this is one lawyer asking another lawyer question. Mark, is the model from the HRA compatible with Momcilovic? And okay. I think you may need to explain that one just a little bit.
Okay. So this is the question. I mentioned that the proposal from the Human Rights Commission is that if a court finds that the particular legislation they're considering is not consistent with this UBA Human Rights Act, then the Attorney General must bring that to the attention of the Parliament and then consider reform. That's the proposal from the Australian Human Rights Commission. A proposal in the Victorian Human Rights Charter said the model that's taken there says that if a court can actually issue a declaration of incompatibility, which will provoke parliamentary debate. The High Court in Momcilovic said that that is not consistent. There was a number of reasons for it, and one of them, particularly by Gummo, was the separation of powers, the concern that I raised as well. So they said that it was not consistent with our constitutional system of government. So the very concerns I was raising. So the Human Rights Commission's proposal is seeking to get around that concern by saying that rather than the court being enabled to issue a declaration of incompatibility, the Attorney General must watch all judgments, and then wherever a court says it is incompatible, then he must bring it to the attention of the Parliament. So there's a sidestepping around the basic issue, and the basic issue stays the same. It's the separation of powers and enabling judges to really have purview over policy considerations which should be the subject of democratic contestation in our parliament. Make sense?
That makes sense to me.
Yeah.
Okay, 3 minutes before lunch. Now, I did have to step away for the last 5 minutes of your talk, so forgive me if this has been answered already.
Yep.
But I'll give you a blank piece of paper. What legislation do you want written?
Do I want written? Okay. Well,
So we've seen a number of the models, and we've seen a number of the
Yes.
approaches, and we've talked about some of the risks.
Yep.
If I was Prime Minister for the day, what would you tell me to do?
Okay, I would certainly be looking to the religious discrimination bill the last government put forward, because it was so laced. By my count, there was something like in excess of 40 differing provisions in that Act that were clearly identifiable as at the behest of religious leaders. So things such as we don't want judges weighing into, as happened in the Coburn matter in Victoria, where Justice Maxwell effectively said, even if we did that, the camping case, where the Open Brethren movement refused a booking from an LGBTI group to use their camping facilities, Justice Maxwell said, we don't accept that you believe that because that statement's not in your 1921 trust deed, funnily enough. But then he went on to say that if we did accept that you believe that, that is a matter of private morality, in quote. And therefore, he was interpreting the content of the beliefs back to the religious believer and saying that that is a matter of private morality, you can't put that on someone else. So if we were to have, for example, recognition of the genuineness test, which that last bill did, that will address judges weighing into these matters. I think another major concern is the conversion therapy. And sorry, Monica, I came towards the end of your presentation. I don't know if you mentioned this, but when the debate went forward in Victoria on their equivalent provision, the key test in their prohibition is change or suppress a person's gender identity or sexuality. The low bar is suppress. And what's not, I think, been picked up enough, certainly around the proposal in New South Wales, I know, Mike, you're across this, is if a religious institution were to say to even a bishop, for example, who has said, I am transgender or I am homosexual, if that religious institution were to say, look, we understand the Discrimination Act enables us to say to you, we're happy for you to stay, but you cannot act upon that. That would be enabled by the Anti-Discrimination Act, but unlawful as an act of suppression under the conversion therapy law. So I don't think that there's been enough thought given to the fact that this is a backdoor way of undermining all of the exemptions, even to the level of a bishop, as I gave the example. The same applies for schools and all employment positions in schools. And the Victorian Human Rights Commission have made it very clear it also applies to membership. You cannot say to someone in a parish or a church, I'm sorry, we differ on this particular point. You cannot say that we cannot allow you into leadership, because that would be, and it actually says this on the Victorian Human Rights Equal Opportunity Commission website. So there's a lot of stuff bundled into this suppression proposal that is, I think, not yet fully explored.
So just to paint you into a corner,
it's all right, I'm a lawyer, I'm used to being painted into a corner.
You'll do it better than me, so you'll just fight your way out and I'll...
Yes.
But the Religious Discrimination Bill, as pre-amended, as was settled coming into the previous election before everything went bad,
Yep.
that you would be recommending that religious communities would be picking up that and advocating that that is the direction that we should be pursuing?
Yes, and indeed, look, there's many more things that leaders were asking for at the time, Mike. You've probably seen some of the correspondence and so on. So, yes, but I think that's an important threshold, a minimum threshold. I think that if there is any great aberration, well, let me just say that I've often said, there's a lot of bishops now around Australia who are the equivalent of second-year lawyers in discrimination law, in terms of their knowledge of discrimination law. Monica would agree with that. And so any particular aberration, any movement from that template will be seen as possibly a watering down of protections.
Yep.
So I think for that reason, that's very much a good place to start. And in many respects, because there was a residue of concerns, the Labor Party could pick up a number of the things that were being asked for, including in the Parliamentary Joint Committee on Human Rights and the Senate Legal and Constitutional Affairs Committee, where it was clear what they were asking for more. A lot of those matters were not contentious.
Excellent. Well, I think I'm getting to at least a first-year discrimination law, so
yeah, I'm sure you are.
You can keep bringing me
I'm sure
along. Thank you so much. Would you thank Mark?
Okay.